Donald Trump and his 18 co-defendants in the Georgia election interference case were scheduled to be arraigned tomorrow in a Fulton County courtroom. But all of them have now waived that right and have entered pleas of not guilty. And while all of them have followed Trump's lead in waiving their court appearance, it does not appear that all of them are showing their unwavering support for him. Politico reports that some have already begun placing the blame at the feet of the twice impeached, 4 times indicted on 91 counts former president, including 3 of the Georgia fake electors, Sean Still, Kathleen Latham, and David Schaefer, who have asserted in court documents that their actions were all taken at Trump's direction. And Trump's former White House chief of staff, Mark Meadows, used his hearing last week to downplay his role, including in the infamous phone call with Georgia Secretary of State Brad Raffensperger, especially compared to Trump's role. Meadows' lawyer pointed to his client's limited speaking role on the call and in court asked Raffensperger, quote, "He didn't make a request that you change the vote totals, Mr. Meadows himself." "Correct," Raffensperger replied. And in pure Trump fashion, the famed grifter is continuing to fundraise not only on his mugshot, but also on the fact that he isn't even appearing at tomorrow's arraignment, all while continuing his attacks on Fulton County District Attorney Fani Willis. Joining me now, former U.S. Attorney Barbara McQuade, professor at the University of Michigan Law School and MSNBC legal analyst, and Tia Mitchell, Washington correspondent for the Atlanta Journal-Constitution. Thank you both very much for coming to the readout. Barb, let me start with you. How likely is it that we will see more of the co-defendants point the blame at Trump?
I think we're going to see quite a bit of this, Jonathan. I mean, at its milder end, we'll see things like I was acting at the direction of the former president. I was just following orders. My job is to do what he asks me to do. I think, though, those defenses are likely to fail because following an illegal order is itself illegal. But one other point to remember is, in addition to the 18 co-defendants in the Georgia indictment, there are 30 unindicted co-conspirators. Those are people already signed up to cooperate against Donald Trump. So often we see that cooperators, as the trial date nears, increase in numbers. So among those 19 people on the defendant list, I think we can see a paring down of that number as more agree to cooperate and cut themselves a deal to get lenience in their sentencing.
Mm-hmm. You know, tomorrow, Barb, Judge McAfee will hold a hearing to consider the motions by Chesebro and Sidney Powell to sever their trials from the other co-defendants. Legally, could the judge say to everybody, whether they've asked for a speedy trial or not, or a severance or not, you're all going to trial in October?
He could in theory, but I think it's unlikely. And that's because he wants to make sure that the defendants all get due process. And I think the request to have additional time to prepare for trial seems reasonable. October strikes me as quite quick. A defendant has a right to a speedy trial, but is not required to have a speedy trial. They are entitled to sufficient time to get their defense together. Now, the government, of course, also has a right to a speedy trial. So a judge has to sort of balance those interests. So it seems more likely that the likely outcome is to sever the cases, allow those who want that speedy trial to go to trial in October, and then for the others to set another trial date, maybe see how this list gets pared down based on guilty pleas, and set a trial date that's a little more reasonable for the remaining defendants.
So Tia, as we all know, Fulton County DA Fani Willis, she brought a RICO charge. That's why all 19 of these folks are jammed into this one case. But if judges grant the motions to sever these cases, is the DA prepared to try not one big case, but say 3, 4, or 17 individual cases?
I think if we were to ask DA Willis if she had to do it all separately, could she? I think she would say yes. You know, she's said all along that she's taken this very seriously and has really tried to be as thorough as possible, as deliberate as possible. That being said, that would not be her wish. That would not be her preference. I think she probably knows at this point, especially with those who've asked for speedy trials, that she won't be able to prosecute all 19 together. Maybe she knew that all along. And I think they're prepared for perhaps going in groups. But if they decide to do them all individually, that would become very cumbersome just from a logistics standpoint. But I think she would be prepared to roll with whatever came her way.
Mm-hmm. You know, Barb, today, Ken Cheeseborough, this afternoon, he filed a motion to dismiss the indictment against him completely and saying any illegal actions he may have taken would be a violation of federal law, not state law, under the Supremacy Clause. Supremacy Clause, the charges against him are invalid. I'm no lawyer, but that seems like a Hail Mary pass. I mean, your thoughts on this? Is that even going to stand up?
I don't think so. You know, I think for those defendants who were federal officers at the time they engaged in the conduct that's alleged in the indictment, I think they've got a plausible argument here. I think ultimately it fails because what it looks at is if they are acting solely within the four corners of their job description, then they are entitled to governmental immunity under the Supremacy Clause. But to the extent they were acting beyond the scope of their authority, even a Mark Meadows, if he is doing campaign activity, which is not what taxpayers pay him to do, instead of doing his job as chief of staff, he doesn't have that defense. And so for someone like Kenneth Cheeseborough, who was not even a federal official at the time of the alleged conduct, I think that defense is much less valid. Now, it does say, or people acting under their direction. So maybe he's latching onto that language, but I think that it fails not only for Kenneth Cheeseborough, but even those who actually were federal officers at the time of the conduct alleged in the indictment. Mm-hmm.